Hello friends, I hope you all are doing well and staying safe at your own place. I, C.A. Pujin Kapadia, welcome you all on my today's lecture on the subject Mercantile Law. As you know, we had started with the topic of the Indian Contract Act 1872. Today, we are going to start with a new topic under this head. The name of the topic is Capacity or Competence of Parties. Basically, we had covered this particular topic at the time of studying the essentials of valid contract, under which I had explained you like what is the capacity or what is the competency of a party to be a party to an agreement or a contract. So basically, we had learned that not all the persons are eligible to enter into a contract, under which I had explained you. For example, minor is not eligible to enter into a contract. A person with unsound mind or mentally unstable is not eligible to enter into a contract. So in this particular chapter, we are going to deal with those parties which are not capable to enter into the contract. So my first slide, as it is being visible on your screen, it reads as capacity of parties defined under section 11 of Indian Contract Act 1872. Parties should be competent to contract, that is they should be. Now here is the list of the parties, those who are competent, or we can say they are capable enough to enter into the contract. So there are certain criteria which are being laid down under section 11. Let's take a look at each one of them. First is he should be major. Major in Indian law is 18 years of age or above. So if any person is below the age of 18, then he is incompetent to enter into the contract. That is not eligible to make a contract. Second is he should be of sound mind. That is, he should be mentally stable. And the third one is he should not be disqualified from contracting. That is, he should not be lunatic, which means he should not be mentally ill. Second is he should not be drunkard. I had explained you this part also, who is a totally alcoholic person. Those person are not in a present state of mind. As a result of it, they are also not competent to enter into a contract. And the third one is insolvent, which means you are already declared as insolvent. That is, you are not having sufficient personal assets to pay off your existing personal liabilities. Then you are under no position to enter into a valid contract. So this is the basic slide. That is, if any question comes up from this chapter, you can write the first paragraph as this particular slide. Like as per section 11, who all are qualified or competent enough to enter into a valid contract. So first point is he should be major. Second is he should be of sound mind. And third, he should not be disqualified from contracting. That is, he should not be lunatic, he should not be drunkard, and he should not be insolvent. I hope I'm clear with this particular slide because we had dealt with the same slide at the time of studying essentials of a valid contract. Let's move ahead. We are going to deal with the answer provisions of the Indian Contract Act with respect to minor. Before starting this particular answer, I would just like you to tell you that this question is one of the hot favorite question from the viewpoint of examiner. If you take any of the previous year's paper, in most of the question papers, you are going to find this question as a long answer. Like state the provisions with respect to minor in Indian Contract Act. As a result of which, I would suggest you all to please study this particular answer in such a manner that you can memorize it as we are going to study it as of now only, so that you can easily answer the same in your examination. So consider it as the most important question from your entire syllabus of Mlaw. So let's start what we are going to study. We are going to study the provisions with respect to minor as per Indian Contract Act. First of all, the introductory slide says, who is minor? Fine. Section 3 of Indian Majority Act 1875. Now here it is the name of some another act. Fine. So you need to remember this name. Where the definition is given, it is being given under section 3 of Indian Majority Act 1875. Let's read what is written over there. Every person domiciled in India, that is having a permanent place of existence in India, is deemed to have attained his majority when he has completed his age of 18 years and not before. So what is the common law saying? That if any person who is being existing in India, he is supposed to be told that he has attained majority if he has completed 18 years. Before that, he would be considered as minor. So this is the most important point you need to remember over here, that is 18 years. So 18 years is the bar of majority. If you have completed the age of 18 years, you will be considered as major. Below that, you will be considered as a minor. Where it has been defined, it has been stated under section 3 of Indian Majority Act 1875. However, there are certain exceptions to this general point. Fine. Now let's see the exceptions. Majority is attained at the age of 21. Above we have studied that it is attained at the age of 18, which is our general rule. But in the following two cases of exception, instead of 18, we are going to aim at 21 years. So the person, if he is falling under any of these two categories, he is going to be termed as a major if he has completed 21 years and not 18 years. Please take a note of this particular point. First point is, when guardian for minor, guardian is basically, you can say, the caretaker of the minor. Fine. So when the guardian for the minor is appointed by the court of law, when law appoints any person as a guardian for the minor, that he is the one who is going to take care and look after the minor, and in that particular case, that minor is supposed to attain his majority not at the age of 18 but at the age of 21. And the second is, when minor's property is taken over by the court of wards for management. Now sometimes court give the decision in such a manner that minor, being minor, fine, he won't be able to manage his existing property. So what does the court do? They take over the property for the purpose of management. That till the minor attain the age of majority, the entire management will be done by the court, so that no one else take that property in a wrong manner. So just to take care of that particular property, just to manage that property of the minor, it is being taken over by the court of wards. Now in this particular scenario, in both the case, the first one was when the guardian was appointed, and second when the minor's property is taken over by the court for management. In both these cases, friends, the age of majority is 21 and not 18. I hope you are clear with this particular slide. I'm just giving you a moment. Take a quick view on this particular slide. Well, I guess you are clear with the points which are mentioned on this particular slide. So by now we are clear like who is minor and when he attains majority. So in general case, it is 18 years, but in the exceptional cases, that are the two cases which are mentioned at the bottom part of this slide, the age is 21 years. Let's move ahead and check out each and every point which are mentioned in the Indian Contract Act 1872 with respect to the minor. So friends, now we are going to look after each and every points of provisions with respect to agreement entered into with the minor. The first point is, minor's agreement is void ab initio. I hope you are well aware about the meaning of the word void ab initio, because we have already studied this particular part at the time of classification of contract. In the first point I have mentioned its meaning. Void ab initio means void and inoperative from the beginning. I had explained at that particular point of time also that as soon as I'm entering into an agreement, it is becoming void. Fine. So from the very beginning itself, at the time we have entered into an agreement, the agreement is not having any kind of existence. It is null and void. So it is not operative in the eyes of laws. Such agreements are known as void ab initio, under which we had taken the same example of the minor, that whenever we are entering into an agreement with the minor, it is void ab initio, which means that agreement is not having any kind of validity at the time it is entered. So basically from the beginning itself, your agreement will be considered null and void. I hope I'm clear with this. So this is the case. Whenever you are entering into an agreement with a minor, the agreement is known as void ab initio. It is not having any kind of legal existence from the time it is made. Now here there was a one case law. Now I would request all of you to remember this particular name of the case law, because this is one of the most famous case I can say, which is always being quoted at the time of studying provisions with respect to minor. So yes, I can say it is compulsory to learn this particular case law's name, and you need to write the same in your examination. The name of the case law is Mohori Bibi versus Dharmodas Ghosh. It was being taken place. The verdict was passed in the year 1903. Now let's see what was the case. D was minor. Fine. D means Dharmodas Ghosh. He was minor. He received money by mortgaging his property. So basically, what was the scenario? D was having certain immovable property in his own name. What he did was he mortgaged his property. That is, he kept his at as security, and he wanted funds. So he has approached some person, and that person, that is the lender, which I was mentioned in the second point, has accepted to lend rupees 20,000. Means D had given his property as a security, and on that particular property, by mortgaging that particular property, D has made an agreement to accept rupees 20,000. So lender was okay to lend 20,000, of which he has already lent 8,000. So 8,000 rupees were actually given to D. I hope you are clear with the scenario, the facts of the case. What is it? D, who was minor actually, was having the immovable property in his own name. Now he was in want of funds. So what he did, he gave his property as a mortgage to the lender, who in return agreed to lend him rupees 20,000. Initially, that lender has given rupees 8,000 to D. So the scenario over here is the property is being mortgaged, against which there was an agreement to take a loan of rupees 20,000, of which D has already received rupees 8,000. Now later on, D sued for setting aside the mortgage, he being minor. Later on, what D did, he said that he was minor. So basically, there cannot be any kind of agreement that can have a legal existence. As a result of which, the mortgage that was being entered into was null and void. So he sued the lender to free his property from the mortgage, because this agreement was not having any kind of legal existence. So I hope you are clear with the case. Initially, D only went to take the money, fine, and later on he is suing the person to keep aside the mortgage because he was minor. So no contract can be entered into with a minor. It was held in the court of law that the agreement was mortgage was null and void. That is, it was void ab initio, as a result of which there cannot be any legal mortgage, fine, with respect to minor. As a result of which D, that is minor, was not required to return rupees 8,000 what he has received from the lender. In short, what we are supposed to remember over here is any agreement which is being entered with a minor, when he is minor actually, fine, you cannot enforce that particular agreement. It is void ab initio, that is, it is null and void from the very beginning when the agreement was entered into. So this is the case, the name of which is Mohori Bibi versus Dharmodas Ghosh. I would request all of you to please memorize this particular name and quote the same at the time of writing your answer. So the third point is minor's parents or custodians, that is the person who is going to take care of the minor, shall not be liable for the dealings done by the minor without their consent or knowledge. Now suppose minor enter into some agreement, but their parents or his guardian is not aware about that particular agreement. If there is no knowledge or no permission from the parents or custodians, they cannot be held liable to pay off the loss which are incurred by the third person due to entering into the contract with the minor. So basically, it is as practical as that. If parents or custodians are aware or they have given permission to the minor to enter into the contract, then they are liable for the same. But if minor has entered by himself, he has not taken any kind of consent, or the parents or custodians are not having any kind of knowledge that minor is entering into such agreement, then parents or custodians cannot be held liable for the same. I hope I am clear with this particular slide. Giving you a moment, take a view at all the points which are mentioned on this particular slide. Well, I hope you are clear with this particular slide. So the first provision that we had studied is any agreement which is entered with a minor is void ab initio, which means it is null and void from the very time it is entered into. Let's take the second point. Minor can be promisee or beneficiary. What this point basically wants us to say that whenever any agreement is entered into in such a way that there is no liability of the minor, but minor is actually the beneficiary, he is going to get benefited out of this particular agreement. So minor is not required to pay anything, but he is going to get something, he is going to be the beneficiary, then such agreement can be entered into. So basically what they are telling, any agreement with minor is void ab initio. That is true. But minor can be the promisee or the beneficiary. So when he is at a position, when he is getting benefit of something, then we can enter into a contract where minor is going to get benefited. Then such contract are supposed to be valid ones. Let's take a look what is written over here. First point is nothing can deprive minor from being a beneficiary. This basically means no one can stop that minor cannot be beneficiary. Minor can be a valid beneficiary to any agreement or the contract. Second is any agreement under which a minor in whose favor a mortgage has been executed can get a decree. Decree means order for enforcement of the agreement. So basically what this point wants us to say that whenever I'm entering into a contract under which minor is going to get the favor, he is going to get benefited by the agreement of mortgage, then such agreement can be enforced, order can be passed to enforce such agreement. Why? Because here the agreement is in favor of minor. Minor is going to be the beneficiary by this particular agreement. So the court of law can easily pass the order for enforcement, that is to implement this particular agreement. Third point is promissory note can be executed in favor of minor. I hope you all know what is promissory note. Suppose I am promising to pay Mr. X rupees 10,000 after 1 month. Fine. So basically this is a promise where who is going to pay? I am going to pay. But who is going to get benefited? Mr. X. How much rupees? 10,000. So the amount is also specified. The person to whom I am supposed to pay, he is also specified. And the time period is also specified. Now this is a basically promissory note. So whenever any promissory note is executed in favor of minor, that is someone is promising to pay minor, then such promissory note is also considered as a valid promissory note. Why? Because again minor is the beneficiary by this particular agreement. So yes, promissory note can be executed in favor of minor. And the last point is minor can also negotiate or endorse negotiable instrument so as not to incur liability upon him. Now let's take ahead this particular example. What I have done, I had promised to pay rupees 10,000 to Mr. X, who is minor, fine, after 1 month. So there is a promissory note which is executed in favor of minor. Now suppose minor has certain liability, fine, he has to pay someone some amount. So what he can do is he can negotiate or he can endorse this particular promissory note in favor of that person to whom this amount was supposed to be paid. So in our example, I had issued the promissory note in favor of minor. So minor is going to get benefit of rupees 10,000. But now minor had incurred certain expenditure and he was liable to pay rupees 10,000 to Mr. A. Fine. Now in this particular case, he has the right to endorse this particular promissory note. So what he is going to do is he is going to assign the rights of the promissory note from himself to Mr. A. So now I am supposed to pay rupees 10,000 directly to Mr. A on the maturity date. So this is also possible. So when such agreement is entered into, to negotiate or endorse the negotiable instrument so as not to incur any liability upon the minor. What is my main objective? That minor should not be liable for anything. As a result of which, yes, minor can also negotiate or endorse the negotiable instrument. I hope I'm clear with this particular case. Only thing you need to remember in detail in crux is that minor, if he is made beneficiary of any agreement, then yes, it is being valid. Any agreement can be made if it is in the favor or it is in the benefit of the minor. If any agreement is such where the liability is created on the minor, then such agreements are void ab initio. I hope I am totally clear with this particular point. Okay, let's move ahead with the third point. This is one of the most important point. its name as no ratification. Now, first of all, it is important for all of us to understand what is the meaning of the word ratification, because you may be studying this for the very first time. So in the first point, I have stated the meaning. Ratification means the action of signing or giving formal consent to a contract or agreement, making it officially valid. What basically this point explains us is, whenever I had entered into a contract or agreement, but this is just we have prepared the draft, we had not signed or sanctioned that particular part. Ratification means when you are doing any action like signing the particular document or giving your formal consent, that is your formal approval to any contract or agreement in order to make it officially valid. See, unless and until the agreement or contract is not signed or not verbally approved by the parties to the contract, it is not valid. When it becomes valid, when a formal consent is given into or where it is signed by the parties to contract. So ratification basically means the contract that you had entered into, now you are giving the your sign or you are giving your formal consent. Why? Because you want to make it officially valid. This activity is known as ratification. So you can easily remember this as that it is an activity that by action, that is by signing or by giving the formal consent, you are making any agreement or any contract officially valid. This activity is known as ratification. First of all, it is compulsory for us to understand what is ratification. I hope that is clear to you. Let's move to the second point. A minor, on attaining majority, cannot ratify an agreement entered into while he was a minor. This point is, you can say, the crux, the main line of this particular point. I'm reading it once again for your clarity. A minor, on attaining majority, cannot ratify an agreement entered into while he was minor. So what this point basically wants us to say is, when an agreement was entered into when I was minor, fine. So agreement was entered when I was minor. Now I'm completing my 18 years and I'm becoming major. So after becoming major, I cannot ratify, that is, I cannot give my consent to make the contract officially valid, which was entered when I was minor. So what does this provision says? You cannot make the agreement or contract officially valid when it was entered when you were minor on attaining your majority. So any agreement again which is entered when you are minor is void ab initio. You cannot ratify it. You cannot give it formal approval when you become major. Contract entered into at the time of minority is always going to remain void ab initio. That is, in future also you cannot give it a legal point. I hope I'm clear with this particular line. Okay, fine. Next point is, since the minor's agreement is void ab initio, it cannot be validated by any subsequent action. This is what I would explain to you just now, that whenever I'm entering into an agreement with a minor, it is void ab initio, which means at the time I'm entering into the contract or agreement, it is void. It is not having any kind of legal existence. So since the nature of this agreement is void ab initio itself, it cannot be validated by any of my subsequent action. That is, if I'm doing any activity which is making it valid, it is also not going to be considered as a valid activity. Why? Because this agreement is already void. It is already void ab initio. As a result of which, I have mentioned over here that any subsequent activity or any subsequent action in case of ratification is also not going to make our agreement a valid one. And the last point is, however, if a fresh agreement is entered into by the minor on attaining majority with proper consideration and proper promise, it will be valid. Now let me take an example so that you may get a proper clarity. Now, when I was minor, I had entered into an agreement to pay rupees 1000 to Mr. X. Fine. So basically this is an agreement to pay rupees 1000 to Mr. X when it was being entered when I was minor. It is considered from the point number one that whenever any agreement is entered with a minor, it is considered as void ab initio. So this particular agreement is not having any legal existence. Now I am attaining majority and I am telling Mr. X that what promise or what agreement we had entered into when I was minor, I am ready to fulfill that particular agreement and I am ready to pay you 1000 rupees. So Mr. X will come to me and he will say, sir, pay me 1000 rupees that you had promised when you were minor. I will say, the agreement was entered when I was minor, so it was not having any legal existence, as a result of which I am under no obligation to pay you rupees 1000. So this is basically the concept that we have studied. An agreement which is entered at the time of minority cannot be ratified on attaining majority. But again, in the same case, let's take the another scenario. When I was minor, I had entered into the agreement to pay rupees 1000 to Mr. X. Fine. But this was void ab initio. Now, when I'm becoming major, I'm entering into a fresh agreement. I'm making a new agreement and I am going to pay rupees 1000 if Mr. X provides me certain goods. Now, here I am having a proper consideration that I'm going to receive certain goods from Mr. X, in return of which I'm going to pay rupees 1000. Now, see, friends, here the previous agreement that I had entered when I was minor is actually void ab initio. So it is not having any legal existence. But on attaining majority, I am entering into a fresh agreement, which is having a fresh promise, which is having a fresh consideration. As a result of which, such agreement will be considered as a valid. So only thing you need to remember over here is you cannot give official validity to the agreement which was entered at the time of minority. So you cannot ratify those agreements, but you can surely enter into a fresh agreement after attaining the majority. I hope I'm clear with this particular point. So today we had taken three provisions. First was any agreement entered with the minor is void ab initio, that is null and void from the very beginning. Second is minor can be promissory or beneficiary. So any agreement which is entered to give benefit to the minor, it will be considered as a good agreement. And the third is agreement entered with the minor cannot be ratified, because it cannot be made officially valid. Furthermore, there are many points under this topic which we are going to take care of in our upcoming lecture. So for now, today, I, CA Pujan Kapadia, thank you all for your patient listening and hope to see you soon in my upcoming lecture. Thank you, friends.